Hey there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness Podcast. I'm here with my co-host, Walter Dials, CPA and tax partner at GRF CPAs and Advisors in Bethesda, Maryland. Our mission here on the Exit Readiness Podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building a sellable or transferable business, and then for planning your eventual exit from the business. We want to help you exit your business successfully and on your own terms and conditions. Walter, a fairly significant percentage of the business owners, I think you would agree, that we talk to and work with have some level of interest in potentially selling their business to insiders, key employees who have helped them build the business, co-owners who also work in the business, or perhaps their kids who are in the business or family members.
Yeah, I think that's right, Pat. That's probably, it may even be the majority of the transactions we've done have been transfers to insiders. And it always surprises me, just the different aspects that really need to be examined in that transaction. You need to look at the insiders, are they willing to become owners? Are they capable of becoming owners? And then there's just all the tax and legal considerations that need to be taken into account.
Yeah, so we've learned, I think, that owners often assume, or at least at times assume, that a transfer to insiders is going to be a lot easier than to make a third-party transaction happen. And, that couldn't be further from the truth, as there's so many moving parts and potential pitfalls to plan for, such as what we're going to talk about here today. Today's topic is the legal and tax considerations when structuring an insider sale. And our guest today is Mark Schweighofer, tax attorney at the law firm Stein Sperling here in Rockville, Maryland. Excited to have Mark with us. He has extensive experience with not just domestic, but international tax matters, assisting clients in structuring their affairs with a sensitivity, if you will, to U.S. income tax considerations. He represents clients before the IRS on complex tax issues in a lot of different areas, including partnership and corporate income tax examinations, employment taxes, and personal income tax matters. And he especially likes working with clients like ours who are transitioning their businesses one way or the other, either through a third-party sale or insider sales, whatever it is. And he's a frequent speaker on issues surrounding selling and monetizing of business assets. So Mark, welcome to the podcast. It's great to have you here with us today.
Thank you very much, Pat. Walter, thank you as well. I'm excited to be here. Let's have some fun.
My first experience I shouldn't say my first experience with your firm, because I've worked with you guys on a number of issues, but one of my first times I used you guys was had a brand new client show up, and the reason he showed up was because the IRS agents who carry guns had just been at his house.
Yeah. Those aren't the agents. You don't want any of them typically. Those are the ones you definitely don't want.
So as soon as he told me that, I was like, I may not be a genius, but I think you need an attorney. So I called you guys, and it actually worked out really, really well. The guy's still a client. The IRS hasn't shown up in the intervening years, so that's been good. So let's discuss the topic on hand. So Pat and I work a lot with owners of closely held businesses, and oftentimes, one of the big goals for them when it comes to their exit is they want to maintain the culture of the firm. And, to a lot of them, their employees are like family. So they're really interested in a sale to insiders if they can make it work. So I guess my first question for you is, alluding back to what Pat said, are there times when the sale to insider transaction is almost more complicated than the other routes?
Yeah, that's a very good question. And I think to some extent it depends on, it's a matter of perspective, and it definitely depends on the nature of the business and sort of the makeup of the insiders and whether they have whether they have the wherewithal to kind of pick up the baton and carry on the legacy that, that the founders typically are the ones that have established. On the one hand, it's like sales to an outsider is, that can be pretty complicated. There's, a significant amount of due diligence that goes on sort of up front. But more often than not, once you get through that sort of, 2, 3, 6 month window when you're kind of pushing, powering through the due diligence phase and negotiating the documents, most founders are able to exit then and kind of sail off into the sunset. With transitioning to insiders, you still have some of those due diligence concerns, and so you have insiders who are going to want to, they may not have had all the access to the books and records that they would typically want to have, or that we would typically recommend that an owner would provide, so that they can make an informed decision about purchasing. But more often than not, most insiders don't have sort of the wherewithal to come up with sort of an upfront cash payment, or at least not a significant one, to the same extent that an outside third-party acquirer would. Right. So, so that lends itself to kind of a couple of different, considerations, I think. And one is sort of, is the business owner, willing to sort of self-finance that, which I'm sure we'll get into it here in a minute. That opens a whole nother can of worms, because it sort of defers the payment. It sort of keeps the, at least to some extent, it keeps the business owner or the founder sort of more involved than he or she may want to be. So timing is an issue there. And then, if the other approaches that you tend to see are, can you get some outside external financing that, that may be lent to the business, that requires, that can be used then to sort of buy out the founder. But, often there, you kind of find yourself in the same spot, because an outside lender are going to require personal guarantees. And usually the folks who are kind of coming up through the rank don't have, or may not have, the financial wherewithal to sort of back that to the same extent. So, it's, as I kind of look at it, the sales to outside third parties are a little bit more work sort of upfront, than a sale to an insider, but certainly it gets a little bit thorny, and you really want to think through, how much you're still involved, and some of the issues that continue to kind of crop up on an insider sale, for sure.
Yeah.
Yeah. So oftentimes, one of our mantras is, Mark, you can't start planning soon enough. And I think, one of the things that we do is test assumptions, because most business owners that we work with, they're coming into, they've already made certain assumptions about how they're going to exit. They may make an assumption about what their business is worth. More often than not, it's worth more in their minds than what it's really worth. But they can make assumptions along the lines of what you were just talking about. How long it might take to transfer a business to insiders. And some of the issues, of course, that we see are, first off, and you've mentioned a couple of these, are the insiders willing and capable? They might be willing, but are they capable? And then not only are they capable, but are they capable of being partners? If there's more than one, they may work well together as employees, but they may not be suited as good partners. They may have other values-based goals. The owners, the selling owners, that would lend toward an insider sale. Maybe they want to continue the culture. Maybe they want to care for employees, whatever it might be. But one of the big issues is this whole area of financing that you just brought up. And so if an owner waits until the last minute, let's say they've got in the back of their mind that I can always just, my insiders have indicated a willingness, I think they're capable, and maybe they are. So I can just wait until I'm ready. And then we can figure out how the deal is going to work. I'll end up financing some, but I'll get the bank involved. I got a good banking relationship. what do you see? Where are the pitfalls in that whole deal structure, and particularly when it comes to the financing, if they wait until the last minute?
Yeah, I mean, you raised all of the kind of the key considerations, I think, and I echo that you really can't start soon enough. Whether that's in terms of identifying key people, because that can take, that takes a long time. It takes a long time to build up relationships, and like you said, it gets even more complicated if there's not sort of one, if there's a single individual who's going to step up and kind of take the baton and run with it. That's something that's a little bit easier to deal with. But when you have multiple owners that you're transitioning to, that adds a whole nother level of complexity, because, not even though they may have been fantastic employees and great teammates as employees, but once you put on that ownership hat or that partner hat or whatever, however you want to deal with it, it gets to be significantly, more complicated. And look, and banks are sensitive to those issues, and outside financing sources are sensitive to those issues, and they're going to look at it and say, well, look, yes, you have a 5, 10, 20-year track record of doing, of having year-over-year profits and really sort of excelling, but that's based on, that was built on your back, Mr. Business Owner, and now it's going to be transferred to your two key people who we understand have been there, but it's a different role for them. And so, the underwriting process is a lot more laborious there. The business, unless it has, a very predictable stream of revenue, and unless it has, or significant, assets that it can pledge as sort of collateral, it's going to make the financing a lot more complicated. And and you're introducing a bunch of different dynamics into this. I mentioned before that it's, very commonplace that if you are going to go and get external financing to, do a management buyout type arrangement, that they will ask the departing founder to personally guarantee some portion of that. And I think that risk only goes up the closer, if you sort of spring this out on the, sort of at the last second. There are some strategies I think you can do sort of along the way that can sort of help mitigate that risk to some extent. And I'll come back to that in just a second. But, in addition, it's the new owners who are coming in are going to be asked most likely to pledge, to put up some collateral or to provide personal guarantees. And, and that's a big change in the dynamics for those individuals too, because they're, they go from being employees, their families weren't necessarily involved, but now you have, you may have a business owner who has to go home and tell her husband or tell, tell their wife that, look, I have this great opportunity, but we're going to have to, put up a personal guarantee, and we both might need to be on that guarantee depending on the lender. So, that creates a lot of anxiety sort of right if it's something that's kind of sprung at the 11th hour, and we're trying to say, look, I'm trying to transition this business, in the next 6 or 8 months to someone without any planning. That gets, I'm not going to say it can't be done and that it can't work, but my experience has been more often than not, the businesses that have been successful have really sort of laid the foundation there even before, they brought, back when, way back early when they started sort of cultivating their talent and identifying key transition people, and finding ways to sort of incentivize them, after the, sort of as they moved up through the ranks. So, that, to your point, Pat, I think that's a very apt one that we want to take, we want to do as much planning as we can, as early as we can, recognizing that we're planners and not, we're not in the trenches. And so it's a little bit, what we want isn't necessarily what the reality of it is, but, the sooner you can get in folks' ears and the sooner you can start thinking about it, the better your outcome will be. At least that's been my experience.
Hey, Mark, there's lots of different tax considerations in this type of transaction too. I mean, one of the interesting things is, generally speaking, a sale to insiders isn't going to be the best option for someone who's trying to maximize their net after-tax proceeds, just for a lot of reasons you mentioned. Insiders don't have a lot of money. Chances are it's going to be a fairly long payout, things like that. So oftentimes the seller is as part of this whole transaction, he's willing to take a little bit of a tax hit to make it easier on the insiders. So oftentimes what Pat and I'll do is we'll set up, we'll kind of use a lower purchase price that we can still defend for as far as the stock value, but then supplement that with a deferred comp plan so the company can have ordinary tax deductions as they pay that out. But what other tax strategies or considerations do you see in this type of transaction?
Well, yeah, and Walter, that's a very good point, and it's it's a strategy that's used quite frequently in terms of setting up a non-qualified deferred compensation arrangement, which obviously there's a lot of tax rules that go around that too, that enable people to get paid out over a period of time. And you're right, there's obviously a big tax rate difference on those sorts of transactions. I mean, the income received by the departing founder under deferred comp plan is ordinary income versus capital gain, if it's with respect to the portion that's paid for their actual shares. You throw in sort of all the uncertainty, at least at the current point, but I think probably if you look back historically, there's always some uncertainty regarding where tax rates are going to go. And the fact that there's these deferred payouts, it sort of makes it even a little bit more challenging to sort of predict what the after-tax effect will be. But I think really one of the things to think about, and again, this is one of the things that, that I think kind of gets missed in the transition planning. And as people start to transition, think about transitioning, to some extent, some of that, it might already be a little bit too late. One of the things you want to look at, I think, very early on is making sure you're in the right tax, the right sort of entity structure to sort of facilitate your goals. If, the buyout strategy for somebody that's taxed as a C corporation is vastly different than somebody than a business that is organized as an S corporation or as an entity that's taxed as a partnership. There's opportunities in each of those where you can, that aren't necessarily available in others, but it's sort of like a seesaw. I mean, what goes up on one end sort of comes down on the other. And so, if you have a partnership type business, it's pretty easy to bring people into equity, on a fairly tax neutral on a fairly tax neutral footing. You still have to figure out ways to buy out, to get the founder out though at some point. And so, anytime sort of regardless of the entity structure, unless you're using some sort of deferred, compensation arrangement, you're paying, the founders are being bought out with after-tax dollars to some extent. And so whether that's the company that's buying them out or whether, and in the worst case scenario, I guess if it's the employees who are buying them out and paying, without deferred comp and just paying, money, paying consideration in exchange for their ownership interest, every dollar that employee has to pay the owner on a departure, they have to pay tax on that dollar first. So, I mean, you're basically down to, you're down to 60 cents or so before you even, before you start on every dollar. So it gets, you do need to be pretty creative in looking at that in terms of, what is the appropriate middle ground here in order for, for the owner to get the, what they need to get out in order to, enjoy retirement and continue to live their life. But you also don't want to throw the baby out with the bathwater from the, from the company's perspective too, where it has this massive, this massive obligation that it can't afford to pay, or that that's sort of, that's crippling for the continuing owners as well. So, and you have the other issues that kind of come up there too, even on, deferred comp and some of the other arrangements, depending on the type of business. You may have third-party lenders. You're going to need to get their consent, to make some of these payments and make sure you're staying within bank covenants and not falling afoul of those. I mean, I do quite a bit of work with folks in the, in the construction industry, and you have folks there in government contracting, in the government contracting space where there's bonding involved potentially, and so you need to get the bonding companies on board. So there's a lot of, there's a lot of nuances there that you kind of have to sift through. But, I will say that the approach that you noted in terms of using deferred comps or some combination of deferred comp and payment for ownership is probably the one that's utilized the most frequently for closely held businesses. but it adds some complexity, and there's definitely an educational element that needs to go along with that.
Yeah, for sure.
Yeah. So in the last few minutes, Mark, and that was extremely helpful. What? And before we leave this the whole area of tax, though, with the businesses we're working with, they're historically they've been 35 million and under in revenue, and then most of them are probably 15 million and under in revenue, and more often than not, if they're going to consider an insider sale, we kind of look towards to the structure as ideally being a pass-through, and so it's another reason to encourage owners to start planning sooner rather than later, because if indeed if the calculation turns out to where it should be a pass-through versus a C Corp, and they are a C Corp, it's going to take 5 years at least for the conversion to take place. Do you have any comments about that before we move on to another topic?
No, I mean, well, yeah, I mean, I echo that. It's not something that you can, unfortunately, and I mean, and I think this really kind of comes up not only with insider sales, but with outside sales and other things too. I mean, if you're in the wrong, you can't really, you're not gonna hit a home run on your business on day one ever, but you can really put yourself behind the 8 ball a little bit if you're in the wrong structure initially. And it's the type of thing that, as you set up, you may want to be, and I've had businesses in my career that I've advised, that, partnership tax entities are the most flexible, particularly in the early years. If you're going to have some pass-through losses, they are great as far as that goes. At some point down the line, an S Corp might, making an election to have it taxed as an S corporation might make sense, because there's some significant payroll savings that can take place, maybe not in any single year, but as you sort of, stack those years on top of one another, you can really generate some significant savings to the owners. And then, if you are going to look at a C Corp structure, which, I mean, and there's a lot of reasons to do that, if you're going, depending on the nature of the business, if you're bringing on, typically this doesn't show up as much in transactions when you're selling to insiders, but, if you're going to take some financing on, you may need to be, the person who's investing in the business may require you to be a C Corp. And we've actually had some pass-throughs, separate and apart from that we have made an election to become a C Corp really in the transition year, partially because we're going to use the company to redeem the shares from the founder. The current C Corp tax rates are pretty low and pretty favorable at 21%. And what being a C Corp will allow you to do, because you can have different classes of stock, is you can issue, sort of a second class to the incoming founders who sort of stand behind the existing class of shares that are owned by the owners. So you can redeem them, you can redeem the owner over time, but yet you can still sort of empower the next generation to come in, without, having to pay a ton of money out of their own pocket, and using company funds to sort of buy people out, or to buy the founders out as they, as the cash is available. So, it's unfortunately, this area isn't one of those where it's sort of one size fits all. I think it really does require some, it requires sort of a team of folks who understand sort of the mechanics and the legal ramifications and the tax implications, but also, advisors who understand their clients and understand their goals and objectives and understand sort of what the business's prospects are going to be too.
Yes. So actually 2 more questions really, but one thing I want to bring to the attention of listeners, and Walter, this will resonate with you. So often when we get a new client or prospective client, they have advisors, they maybe have an attorney that they've had for years who have done all kinds of different things for them. Anything from real estate transactions to maybe wills and some estate planning to employment agreements, just general legal stuff, and done a good job and got them to this point. However, at this point, what we strongly encourage, and I think listeners, if you're paying attention, you can see where there's deep knowledge in this area. and you really need an expert. You need someone whose practice is focused on tax and legal as it pertains to transactions, be they third party, be they ESOPs, be they sale insider. Walter, would you have any comments about that? And then Mark, any comments that you might have as well? We think that's extremely important.
Yeah, I think that's exactly right, Pat. I mean, we see a lot of times where either, a client has kind of outgrown their CPA, or like you said, they started their business using a friend who was an attorney, hopefully at least he was a corporate attorney. But, this stuff is very nuanced, especially from a legal and tax planning standpoint. And you really want to work, like you said, with people who have done it a lot, that aren't trying to figure it out as they go. Just really makes the process a lot easier, and you're going to end up with a better result.
Yeah. Hey, Mark, do you find yourself called in to clean up messes sometimes that have been made by a well-meaning?
Yeah, and I mean, look, that's sort of the nature of the game, I think. Any startup is doing, look, it's different if you have somebody who sold their business a time, and is sort of a serial entrepreneur who's starting something new and understands the pitfalls and the mistakes they made initially. But, ordinarily that's not the cards that are dealt. You're playing the hand you have, and businesses and business owners do what they have to do in order to get the business to grow and thrive. And I'm a huge proponent of making sure that you're comfortable with your advisors. And that's not to say that these folks, the folks that helped you get there, need to be completely out of the picture when when we're doing this either. It's just having somebody with subject matter expertise that this is their focus, may open some doors that some other folks may not have thought about. And so, to me, it's the team is very key. One of the things, I have clients that I've represented from formation to exit. Probably at least as often we're brought in, right at an exit stage or close to an exit stage. And I really enjoy working with the existing advisors for a lot of those clients too, because they know, for lack of a better term, they know where the bodies are buried, and they know where they can help kind of navigate us through the pitfalls of the operational aspects of the business and sort of the institution of the business and the culture of the business. And those are things that you don't want to lose, and make sure that make sure that everybody's sort of rowing in the same direction. So, we do get called in a lot, and we do clean things up, but it's really not to be, exclusionary or to try and say, to throw people under the bus at all. It's really just to make sure that we're getting the best result possible for the client and everybody and all the rest of the stakeholders that are involved.
That's good.
Yeah. So, Mark, let me ask you one more question before we finish up. We always tell our clients when they go into these transactions, look, the worst thing that can happen is you end up having to take the company back. So how much of a nightmare is that? And does it really happen?
So unfortunately it does happen. And again, and this is sort of where I think the planning is important, right? And it kind of goes into starting early. And I think this is where, a well thought out plan and a long-term plan helps the most. I mean, if you're incentivizing your employees for years and you're identifying key people, whether it's through, some sort of phantom stock arrangement or bonus plans or something, and you're also sort of got some restrictions on them too through employment agreements, with respect to confidentiality and non-solicitation of customers and clients and referral sources, and possibly even a non-compete, although that law is getting more difficult for business owners. You've sort of at least set the groundwork there. And then, the businesses that I've worked with that have done the inside transition the best, it's not sort of I'm getting up on Tuesday and I'm, selling you 100% of my shares. It's sort of a staggered approach where, maybe we bring them in for 5 or 10%, keeping control for the founder up until a point where he or she is confident that the folks that they're looking to transition to can kind of, like I said before, grab the baton and run with it. And make no mistake, that's a hard thing for a lot of business owners to do. I mean, they've been successful, they've grown their business. It's tough to give up control. And so that is a very difficult thing to do. But yes, obviously there are strategies that we put in place on virtually all of our insider transactions. If it's seller financed, there's always a stock pledge or some sort of equivalent rights. The founder may continue to be on the board. There may be certain actions that can't be taken, in terms of incurring additional debt, really ramping up compensation for the new owners until, so there are safeguards you can put in place. But there have been a time or two when, look, the business just couldn't, either whether it was, the business environment or climate, or maybe we just didn't identify the right people, where the founder may need to step back in and take control, either for a period of time or indefinitely. And look, those are, I'm not going to say that they're straightforward. Legally speaking, it can be. Practically speaking, because the rights under the agreements are pretty clear, but practically it can be kind of a mess. And so that's one of the things that, again, if you do have to do it, it's there for you. But the further you get, the further the founder is away from the business and they have to step back in, the messier it gets. So ideally, you'd want to have, that sort of gradual transition to the extent you can plan for it, which again, not always the case, but to the extent you can, that seems to work out better from my perspective.
Yeah. So we really focus on a lot of the things that hopefully prevent that from happening well in advance, like preparing the successors to be owners rather than just key employees and partners and so on and so forth. Anyway, that's very helpful. One last question. That I think would help listeners, Mark, if you could just give kind of a summary of the legal documents that an insider sale seller might expect in a typical situation.
Yeah, certainly. So again, typically, and I'll address this assuming that we don't have outside bank financing for now, because that ends up with, that opens a whole nother kettle of fish. You're almost dealing with two transactions at once, because you're negotiating with the lender and you're negotiating sort of with the insiders. So the documents that we tend to typically see are, there's obviously going to be a stock purchase agreement or a membership interest purchase agreement. That's the document that's going to actually transition ownership from the founder to the insiders. That's going to spell out the purchase price. It's going to have, and importantly, it's got to have some things in there too about, some representations and warranties about the purchaser too. We want them to represent that they understand that, look, this is risky, that we have, that these aren't, these types of acquisitions, you're not buying stock of IBM or Google. There's no public market for it. They need to understand that, they're only doing this because they have an insider view of the company, and that's why this is happening. So that's one. Typically, there's also some sort of there's a promissory note, because again, we're assuming that the individual, that the buyers are not going to be able to sort of stroke a check, sort of day one. And those and so that'll have the typical provisions in terms of, what constitutes default if somebody doesn't pay on time, if somebody goes, if the purchaser goes and, declares bankruptcy, those sorts of things, and it identifies the rights and remedies of the founder to, to kind of protect them there. There's typically some sort of a pledge or security agreement, which again, that's the buyers pledging back the shares that they bought. Sometimes the company will also join with a pledge or of some sort, maybe with respect to all of its assets or its accounts receivable, those sorts of things, so that can get recorded through a UCC filing. And then the final document, again, and this changes a little bit depending on whether or not the owner is actually is exiting in full or exiting in part. If it's staged, there's a stockholders agreement or an operating agreement or LLC agreement, depending on which state you're in. And that's going to kind of govern sort of the relationships among the parties, with respect to governance and distributions and, voting rights and transferability of interests and all of those sorts of things that are going to keep the founder in control until he or she is ready to sort of, ride off into the sunset for good. So those are kind of the foundation documents. There can certainly be others that get added on top of that. Some founders will sign a consulting agreement to continue to do work if they're exiting in full. You want to make sure that one of the things I mentioned is, having some sort of restrictive covenants. Stockholders agreements are great vehicles for that. It's much more enforceable there. So like if making sure that, the last thing a founder wants is to sell their business and then have the person they're selling it to, while they're still owed a bunch of money, say, well, look, I can just stop doing this for this company and start my own, and I don't have to pay you the rest of this purchase price. So, having some restrictions there to prohibit that is sort of what the stockholders agreement is designed to do.
Excellent.
Great. That's it's been really, really helpful, Mark. We really appreciate it. So as we wrap up, is there anything you want to promote, and can you tell listeners how they could reach you?
Sure. Well, yeah, I mean, Stein Sperling is, we represent businesses and business owners. That's what we were founded on. We do a lot of M&A transactions, but we're a full service firm. And that's one of the things I like the best about working here, to be honest, and being a partner here, is I have subject matter experts in everything from estate planning to civil litigation, to employment law, which is not an area that I, that is my focus. And so, having that broad bench and having, that well of knowledge to draw on is great, because it's both great, but also a little unnerving. Is like when you write an agreement and then have to see it challenged in court. To have it actually perform the way you intended it to is good. And so having that expertise behind you to help with that is, we've learned a lot over the years, because we've seen a lot over the years.
Yeah.
And so we've sort of been able to draw on that. And then in terms of reaching me, probably the best way is just my direct dial, 301-838-3233. And you could also email me through our website, which is steinsperling.com. I'd give you my whole last name, but I'm not even sure I know how to spell that. So I'll let people click on the link instead.
Great. Thank you very much. Really, really appreciate
Thank you, gentlemen. This was great.
Yeah, thanks, Mark. It was fantastic.
And listeners, if you want help in maximizing the value of your business or planning for your eventual exit, you can reach Pat at 301-859-0860, and you can reach me at 301-951-9090. You can also access resources at exitreadiness.com, grfcpa.com, and nslp.com. As always, thanks for listening. And until next time on the Exit Readiness Podcast, this is Walter Dial and Pat Ennis signing off.